Good afternoon. Welcome to January 21st, 2025 School Board Special Meeting. I want to officially call this meeting to order. I'm now going to turn this over to Mr. Dye, who will begin the meeting with our next course of action.
Thank you, Chair. Hello, board members and Superintendent Quaison. Aaron Jackson's here representing the district. Is Mr. Gray present? So, at least as of yet, Mr. Gray is not present. We're here for the hearing regarding School Board of Manatee County, Florida versus David Gray. This is DOA case number 24-001779. It's a employment termination case that went to an appeal at DOA. The DOA judge issued a recommended order that is included in the record that each of you received. The district's attorney filed exceptions to the order and has also provided a recommended order that contains those exceptions. So this matter was set for hearing. Notice was provided to the parties. I'll ask the clerk, did you receive any documentation from Mr. Gray in response to the notice? So the clerk has not received any documentation in response to the notice of today's hearing. The action of the school board, you end up being the final decision maker. That's what your role is today. And I've sent you some of the excerpts from the administrative code, but I'll go through a few of those and summarize them before we start. So the school board is to be provided the entire record of the proceedings, which I believe everybody did receive an opportunity to review. And the school board may choose to reject or modify conclusions of law or reject findings of fact. This is all set forth Florida Statute 120.57. Each party is given 15 minutes to present its position on the recommended order to the school board. The superintendent makes a representation through the district's attorney, which is Ms. Jackson. After she'll make her presentation, and then the employee has an opportunity to present their presentation or their argument. Each party has 15 minutes. And then the school board, after that, will make a determination of which order you are going to approve. The DOA order or a new order, which the order being recommended by your district, your superintendent is the one Ms. Jackson has provided. Is there any questions?
Thank you, Jeff. Attorney Dye, I just have a couple. Since he's the respondent, correct?
Correct.
Mr. Gray. Since the respondent is not here, do we need to go through all this, or are we required to give him the 15 minutes that it would take us to go through our side of the district side of the case?
I would recommend going ahead and having Ms. Jackson give her presentation.
Okay, that's fine. And then also, just to be clear, you said that the board is the final decider, my word, not yours. And then if we decide to go in a different direction, whether it's a finding law or finding a fact, we have to justify why we did that, correct?
Yes,
We can't just come up with something and say that this is what we want, so it shall be. We have to
Correct.
explain. Okay. And then for the respondent, currently his, I just want to talk about or ask you about possible outcomes. So if the board sides with the superintendent's recommendation, the respondent is terminated as of when?
today,
So termination is effective today.
yes.
If the, assuming there's no changes to statements of fact or statements of law, if the board were to side with the respondent, what set of events going to play that?
It would be what the board decides. The
Yeah,
the respondent's currently on suspension without pay.
Okay, so let me.
And the recommendation was
is-
32 days.
That was the DOA judge's recommendation, was 32 days without pay.
Oh, thank you, okay. So if we choose, though, it's 32 days without pay, but then what would happen to the pay that the respondent has missed out on since he went on suspension? Because that's been longer than 32 days, 32 work days.
I mean, I would speculate the board could address that.
So we could go, all right, we don't need to go to this for too long, because it might all be a moot point, so maybe I should save that question till the may not matter.
Good. Anybody else? Yeah.
So if we do decide to go with the superintendent's recommendation, which is, the term of that is the petitioner's exception to orders, is that correct? That, in the documents that we
Yes,
received,
there's a,
it's called petitioner's exceptions regarding David Gray, is
so
that?
that's what was actually filed in the DOA case,
Okay,
but there's a recommended order that goes along with that.
I see.
So
Okay.
that's,
There's an ALJ order, administrative law judge recommended order, petitioner's exception, request for administrative hearing, notice of recommendation for termination. Is that, okay. That was back in March. So do we have, is one of these documents the current recommendation for, I mean, is that the current, do we have the current?
actually
superintendent?
attached, not in those listed documents, but attached to my email.
One of the
was
emails previously, okay.
And I can give that to
And
you.
I think I saw it, then I just
Okay.
was looking through this documentation too. And then if we decide to go with the superintendent's recommendation, do we have to give any reasons, or can we just say up or down, yes or no vote, or do we have to
You
provide,
can simply make a motion.
simply make a motion? So we don't need to provide reasons of why we didn't accept the administrative law judge order, is that correct?
The reasons are actually incorporated into the recommended
Into the
order.
recommendation?
Yeah.
Okay, great,
You
that's,
don't have to restate them.
okay, great. That's all I had then, thank you.
Anybody else?
I'll have questions after.
Sure.
Yeah.
Okay. All right, Ms. Jackson?
Thank you.
Yeah.
Erin Jackson and Kevin Pendley on behalf of the Superintendent, Wysong, and here on the matter of the School Board of Manatee County versus David Gray and the recommended order and the exceptions to the recommended order that are before you. I think it may be helpful, just because I know that there's a lot of administrative steps to this process. If I could just give you a little background of how we got here in the first place. So there was a recommendation by former Superintendent Cynthia Saunders to terminate Mr. Gray for the misconduct. And I'll get into the details of the misconduct in a moment. But first, I'd just like to talk to you procedurally about how we're here. So that recommendation was made to the school board at the time. Mr. Gray had the right to appeal that decision. And to do so, he needed to just file a notice requesting a hearing. He did, in fact, file that notice requesting the hearing. And when he filed that, the recommendation for termination then just transferred to a recommendation for suspension or administrative leave without pay pending the hearing. In the meantime, before the hearing was scheduled before the administrative law judge for DOA, the Division of Administrative Hearings, the union got involved. And the union filed a grievance and said, rather than going through the administrative law judge and DOA, we'd prefer to go through an arbitrator through a grievance. every employee who is a member of a bargaining unit, a union, has the right to choose a path. You can't do both, but you can choose one path. So he was on path 1, and then the union got involved, and they chose path 2. On the eve of the arbitration, the union called me and said they wanted to postpone the arbitration because they weren't sure they were going to pursue it on his behalf any longer. And that took some time for them to make their decision. They ultimately decided not to represent him and to drop the grievance. And then Mr. Gray said he wanted to reinstate the choice for path 1. So there may be questions about why this took so long, because it's very unusual for it to have taken this long, but that's why. And so then we ended up back on path 1 before an administrative law judge. Under the Florida statutes, the school board has the ultimate final decision with regard to disciplinary action of employees. But employees have the right to pursue a hearing when their substantial interests are at issue. And of course, his employment was at issue. The hearing is before an administrative law judge with DOA. That administrative law judge is making a recommendation to you after hearing the evidence, but it's a recommendation. You all have the authority to make the final decision. And the statute sets out how the process works and what types of decisions you can make. And ultimately, in this case, what we're asking is that we agreed with almost everything that the administrative law judge found in terms of the facts of this case, but where we disagree is with the recommendation for discipline. And under the statutes, again, you have the final decision here, and you have the right to disagree on the recommendation with the administrative law judge and instead impose the level of discipline that you believe is appropriate. And in this particular case, we're here on a recommendation for termination for the misconduct of Mr. Gray. Mr. Gray was working as a school food service worker when he violated Section 4213, which is a school board policy on student supervision and welfare. And he did this when he engaged in a 32-second frontal hug with a very young elementary school student. This interaction was captured on video, and you all have been provided with the record and have been provided with a copy of the video. It was also presented at the hearing to the administrative law judge. The video clearly shows that Mr. Gray approached the student, who then stands up from the lunch table, and then he proceeds to hug her from the front, holding her for this extended period of time, over 30 seconds. The conduct is in clear violation of the policy, and it's also in violation of prior directives that had been given to Mr. Gray. In fact, the administrative law judge found that Mr. Gray had been disciplined for this before. He had been told not to touch students, and the administrative law judge also found that during the regular meetings, supervisors told all of the employees that if a student at an elementary school approaches you, hug from the side, do not do a frontal hug. Mr. Gray knew this. He did it regardless, and he did it for over 30 seconds. He was unable to provide any credible explanation at the hearing for why he did this. Despite the administrative law judge recommending a suspension rather than the termination, again, we don't agree with this recommendation, and the law grants you the discretion to adjust that recommendation. The decision to recommend suspension by the ALJ was influenced by his belief that the absence of contact outside the school mitigated the severity of the violation. However, there's nothing in policy that says that it's okay to have this type of contact with a student in school if you don't do so outside of the school setting. We assert that the recommendations in the order clearly support the termination as opposed to a suspension, because this was a clear violation of policy. It was a clear violation of directives that had been given to him multiple times, and a clear violation of the directive that was specifically given to him in prior discipline. By his own admissions during the hearing, he admitted that he did have regular personal interactions with this student, stating that he cared about her so much and he wanted to hold her. He further acknowledged working with the student on anger issues and supervising her after school. And the video evidence speaks for itself in terms of what happened that day. in the lunchroom. While the employee claims to have engaged in a side hug, the video clearly, unequivocally shows that it was not a side hug. And again, he has no credible explanation for why he engaged in this behavior. So for all these reasons, we respectfully submit that the recommendation for suspension is not appropriate in this case. The conduct in this case, along with the prior warnings and the video evidence, warrant termination, and we urge you to accept the petitioner's exceptions, reject the administrative law judge's recommendation for suspension, and instead issue a final order terminating the employee's employment. We did file with you all last week a proposed final order, setting forth the agreement with the superintendent's recommendation for termination and terminating Mr. Gray's employment effective today. Thank you, and if you all have any questions, I'm happy to answer them. Yes.
Hello, Ms. Jackson.
Hi.
Thank you for your work on this case. So is it a binary option, accept the administrative law judge's order or accept the superintendent's order, or can we do, as a matter of law, I'm just curious, not that I would want to do something different, I'm just curious, is it binary, one or the other, or nothing, or can we do something different?
The law provides that you have the final decision. So it's not binary, it's not just this or that. If you have a legitimate basis for some decision in between, that is an option, but you'd have to state exactly the reasoning for that and why you would accept the administrative law judge's decision.
And what would be acceptable reasons, matters of fact, or I mean, like if I wanted to give a reason why I wanted it to be different, it wouldn't be just my opinion. I mean, it would have to be a matter of fact that I found that was not correct, or a matter of law, or, I mean.
Right, so for the findings of fact, you would have to find that there was not competent substantial evidence in the record to support that finding of fact. And with regard to the conclusion of law, you'd have to find that your reasoning was far more reasonable and that there was an error with regard to the conclusion of law that was reached.
Okay, thank you. That's all I have.
Anybody else? I'm on Granicus, but I don't see. Yeah.
Thank you. For the record, Heather Felton. So I was reading through his deposition, and he stated, in response to your questions, he stated that face-to-face hugs were inappropriate. He even made that statement as well. And I watched the video. It made me uncomfortable. We have record that he's been disciplined previously for a similar thing. Am I understanding that correctly?
That's correct, yes.
And that was not his first letter of reprimand as well. Is that right? There's a pattern of behavior. Am I understanding that as well?
That's correct. He had been issued directives before, coachings and counselings before, and then was issued a written directive with regard to not touching students.
Okay. So in looking at, let's see, I've got it right here in front of me. In looking at the policy 4213, it does state, and this is letter G, a support staff member shall not inappropriately associate with students at any time in a manner which may give, and I'm emphasizing is mine, may give the appearance of impropriety. It says including but not limited to. So it's not just the things that are listed there, including as well as other things. And it definitely made me feel that it was inappropriate. Having been in the classroom, yes, kids hug you, but not that long, and it is usually just a lean in, kind of hug on the side, and I'm sorry you're having a rough day kind of a thing. It's that I also took as very inappropriate. So yeah, I'm not comfortable with renewing his employment.
Thank you. Ms. Fair?
Okay. On the ALJ's report, number 28 is saying that they recommend suspension without pay for 32 workdays. And then it goes on to tell us as board members to make the final decision, basically, okay, without going into law terms. So I have a couple of questions. Letter of direction or anything in his file prior to this incident of any kind of disciplinary issues?
Yes, if you look at, let's see, it's in a footnote 2 on page 4 of the recommended order, the administrative law judge actually walks through the discipline and the disciplinary consequences that were issued to him. 2019, 2020, and 2021, he was issued warnings. And then in 2019, he was also issued a specific letter of direction in which he was cautioned against inappropriately associating with students, i.e. hugging student and patting student's hair. And then the ALJ actually found that this was evidence that respondent received actual notice of the school board's policy 4213 on student supervision and welfare.
Let me rephrase my question. Is there anything in his personnel file prior to 2019?
Oh, I'm sorry.
It's all right, it's me. According to all of the records, he became an employee in 2009. And according to the deposition at a proceeding that you were at, things started to deteriorate with his employment at the school with cafeteria workers and supervisors. And even in that deposition, he is stating how he came to the downtown office to talk to people about some of the problems that were going on. So there's nothing that I could see in this whole report about anything with his behavior until 2019. And then I look at exhibit, well, there's a lot of exhibits. Exhibit C, wait, back up. Exhibit A is a Barbara Harvey Elementary Parent and Student Handbook. Parent and Student Handbook. And it's saying a message from the principal that, and there's one that's highlighted that says, we give away hugs while elevating academic success. And I'm going to get to my point. And then Exhibit G shows the evaluation of Mr. Gray in food service by his supervisor. And that's where I got the date of 4/1/09 is when Mr. Gray became employed. And on his, it meets expectations, developing meets expectations, I didn't see any, the comments I see, Casey is great with kids, another name for Mr. Gray. Food quality is always great, needs to work more on designee responsibilities. So I see that in his file, and that's dated 3/4/22. So, and I saw the video. I saw the video shortly after this incident occurred. And it disturbed me as well. I don't know if I saw the student hugging Mr. Gray or Mr. Gray hugging the student once I started looking at it more intent. And there's only one angle in the deposition. Mr. Gray is saying it was a side hug, but clearly the student is double armed around Mr. Gray's shoulders. So it couldn't have been just a side hug. It did last quite long, but you can't really see the angle on the left side, I guess it would be, from what I could see. So, one, there's no complaint prior to 2019, and he's been with the district 10 years by this time, nearly 10 years by this time. His review meets expectations, great with kids. And then I don't know if there's a problem. I've worked in different areas in my life, and there's always that dynamic, no matter what group, there's cliques within food service, bus drivers, teachers, same thing with any other profession. There's the cliques. There's the administrative clique. There's the people in a business cafeteria clique. There's mechanics. There's everything. So there's always going to be a little bit of animosity within the ranks. And to your point, Ms. Felton, about item G under the student supervisory and welfare. And then when I looked at that thing with the Harvey, we give away hugs while elevating academic success. I don't know if this is something that's been shared district-wide. I don't even see a date on this particular document. 2020, 2021 parent-student handbook. Sounds like there's been a culture, in my opinion, that if a student needs assistance, that we try to offer comfort to them. And touring schools, and I'm sure others up here have witnessed, I have in my schools, where a student just comes out of the blue and will hug you. I'm talking kindergartners through middle school. I've seen students hug staff. But it wasn't that 30 seconds or more embrace. To me, a hug is a hug. An embrace is where I make that definition, an embrace or a hug. So I don't know if there was any, Mr. Dye, was there any other angle of that video provided that this basically defendant could say, hey, it was just a side, according to the transcript, it was just a side hug, but clearly it was a full body hug to me. But I didn't know if there was another angle.
There's no other video in the record, but in the facts and and I'm sure you saw the administrative judge findings of fact there's no disagreement on the facts. And the judge also reviewed the video, and it's in the judge's order. So there's no disputing the facts of what that video shows.
Okay.
The respondent stated it was a side hug, and the judge explicitly says after reviewing the video it was not a side hug.
Right. Okay. Well, that's all I have for now. I want to hear what
Okay.
other board members have to say.
Sure. Mr. Kennedy?
Chad, I'm ready for the motion, but I do want to make sure everybody has a chance to speak. To Ms. Spray's point, having just left an elementary school for 2 years, you get hugged 50 times a day. But what we can see clearly on that video, even only from one angle, is to me very problematic. And I did think the respondent had some interesting explanations for the whole thing, but I didn't find any of them convincing. And therefore, I'm ready for the motion.
Absolutely. Go ahead. Anyone else need to say anything?
No.
I don't need to repeat what's been said, so.
Okay.
Absolutely.
Chair Choate, I'd like to make a motion that we Attorney Dye, help me make sure I get this language right. Make a motion to approve the superintendent's recommendation for termination, effective today.
Secondary.
Attorney Dye, is that a proper motion?
Are you good with it, Ms. Jackson?
Yes, I would just add for all of the reasons set forth in the petitioner's exceptions.
Can outside counsel?
Yeah, Laura, can you guys help Laura with
Can I
that?
support her amendment, motion to amend? Let me start from the top then, Mr. Chairman. Motion to accept the superintendent's recommendation of termination based on the findings of fact laid out by the
It's on here.
Doa Court and the exceptions filed by the petitioner.
And now I second.
Perfect.
So now that we got the language down, Laura, were you able to get that language? Yeah? Yeah. Absolutely. While you're working on that, we do have a comment from Mr. Tatum.
So my comment is that for Mr. Gray, if you're ever watching this and with the other employees in the district, I did spend about an hour and a half or so reviewing this whole package, and it's regretful when we come to a point like this where we have to terminate somebody's employment. We value people that work for the school system. This gentleman has been working for us apparently for over a decade. And so, however, when I look at what you might call the preponderance of the evidence, because it's not a criminal case, it's a civil case in a way, unfortunately, in my judgment, the record comes down to the preponderance of the evidence being in accordance with the superintendent's recommendation. And so I'll be voting to accept the superintendent's recommendation for termination regretfully, but I believe that's the right decision to make in this case.
Thank you.
Yep.
Yeah.
Thanks, Jeff. Attorney Jackson, I just have one more question too. How was the respondent notified of today's public hearing?
How was he notified?
Yes.
He received an email and also regular mail notice, and it was also published.
Okay. So he got two active communications and one passive through the
Yes.
posting of the meeting. Okay. Thanks. Thank you.
So there wasn't a registered letter that went out or anything like that? I don't know if that's a requirement, I'm just asking.
It is not a requirement. In fact, electronic it satisfies it, but we
Satisfies
did both US
Mail.
mail and
Okay.
email. Often, just in general, I will do a certified and a regular. I don't want to tell you for certain that I did that. I cannot remember whether we did it by certified mail as well, but very oftentimes certified mail is not signed for, so I always send by regular mail so that we're certain that
Okay,
it's delivered and not just sitting at the post office.
but we have record that it was mailed, that's all I want to make
Yes, we
sure
have record that it was mailed and
Right.
emailed, yes. And he has, in his communications with me, have been by email.
Okay. Very well, thank you.
We're just waiting on final touches here.
Board, please review that we played with the language a little bit on the motion.
Mr. Chair?
Should the name
Yeah, yeah.
be,
That motion as written captures the spirit of what I was trying to say.
And
should it
Ms.
be?
Belton, seconder.
Yes. All good.
Good.
I'm just asking, should the name of the employee be in that motion at all?
I don't think it needs to be, well, I
Okay.
guess I'll ask the attorneys. I don't think a name needs to be present.
No.
Because it's inside
Okay.
the original
All right.
order. Yeah,
It's all in the same record.
okay.
Okay,
All right, so we had a motion from Mr. Kennedy, second from Felton.
One small thing is
Yeah.
I would put an apostrophe after the superintendent's recommendation. I just can't stop myself as a former
You can
English teacher.
put that later, yeah.
Let's make it correct. So
All
That's
right,
all.
so we have our votes up. Let's go ahead and vote on
Oh.
the motion to approve the superintendent's recommendation for termination based on the findings and facts laid out by the recommended order submitted by Attorney Jackson on behalf of the superintendent.
I'm not in lay legislate, so.
Oh,
I'm an aye vote.
well, yeah, you motioned, so you're good. And I, so
Yeah.
it passes 5-0. And with that, we conclude this special session, and we are officially adjourned.